So welcome back. Let's talk now about copyright. So let's start by asking ourselves what copyright is. What does it protect and where does it come from? So copyright is a type of intellectual property that gives the creator of original works exclusive rights to use and distribute the creations that they make. The kinds of works are broad. They can include literary, artistic, musical, dramatic pieces, and ultimately the predecessor legislation that we have, it goes back many hundreds of years, and over time it's been adjusted to include newer forms of artistic expression, including films, broadcasts, and these days even software. In fact, when I say these days, software has been protected since around the time of the Copyright Act, the 1968 Act, that is the current version of that law. Again, it's important for me to remind you that copyright protects the way that the ideas are expressed, not the ideas themselves. So you can't copyright the idea behind a detective novel, but you can have copyright over the specific way in which the story you write unfolds. Under Australian law, under the Copyright Act 1968, copyright is automatically granted for the moment the work is created or recorded in some form, whether it's written down, recorded, or digitally stored. It's important to understand that the Act itself, one of the key features of the Australian copyright law is that there is no need to register the work for protection. From the moment the work is recorded in a tangible form, the author or the performer of that work is automatically granted copyright. As the owner of the copyright, the author or the creator of the work holds exclusive rights to reproduce, distribute, perform, and display that work. So these rights are extended to adaptations of the work. So it's also important to understand that under the Australian law, and this is not the same in every jurisdiction, there are protections for what we call moral rights. So these ensure that creators are credited for the work that they do and that their work isn't distorted or used in ways that could harm their reputation or the integrity of the work. So let's talk about moral rights in a little bit more detail. You'll find that Part 9 of the Copyright Act deals with moral rights. Moral rights are personal rights that are granted to the creators of copyright-protected works, separate from the economic rights that are associated with the ownership of the copyright. So in Australia, moral rights are governed by the Copyright Act. They've been around since the year 2000, and their purpose is to ensure that creators can retain specific personal rights over the work, even if they don't own that copyright anymore. So there are three key moral rights. Firstly, the right of attribution. So this means that the creator has the right to be properly acknowledged or credited for the work whenever and wherever it's used. This ensures that the public is informed about who the original author is, whether the work is published, performed, or broadcast. So, for example, if a painter's artwork is displayed in a gallery, the gallery is legally required to display the artist's name alongside the work. Similarly, these lecture videos that I prepare for you, the copyright is owned by my employer, RMIT University, but I retain the moral right to have this work attributed to me. Next to the right of attribution, there's also a right against false attribution, sort of the other side of that coin. This is a right that protects creators from having their work falsely attributed to somebody else. If a work is wrongly credited to somebody else, then the creator can take legal action to correct that attribution. So if a photographer's work is published under another person's name, the photographer can object and seek legal remedy. There's also this right of integrity. This is the right that protects the creator from derogatory treatment of their work that could harm their honour or their reputation. It includes mutilating, distorting, or modifying the work in ways that could affect its integrity or the standing of the creator. So if a film is edited in such a way that it distorts the intended message or meaning that the director had, the director, in theory at least, can object to those changes. In Australia, moral rights last for the duration of the creator's copyright. So that's generally, and we'll talk about this in a minute, the life of the creator plus another 70 years. These rights are automatic and they can't be sold or transferred. However, creators can consent to the use of their work in ways that would otherwise infringe their moral rights. So you can't transfer your moral right to somebody else, but you can waive it or agree that it can be infringed or reduced in scope. And employment contracts quite often do that, and it wouldn't surprise me at all if my RMIT contract, to a limited extent at least, addressed this moral right issue. There are some circumstances where moral rights won't be enforceable. For example, if a work is used for purposes like parody or satire, there are exceptions that might apply. If an employer commissions work, for example, in advertising, they can negotiate limited consent for the creator for certain uses. But you cannot completely waive your moral right. Even if a creator consents to certain uses, the integrity and attribution rights are still protected to a reasonable extent. And what happens if moral rights aren't respected? If they're violated, then creators can seek legal remedies that include injunctions to prevent further infringement, damages for harm that's caused to their reputation or their good name, and thirdly, corrective measures such as public acknowledgements, apologies, or attributions. Really good source of information about this is the Copyright Council website. They have a downloadable guide on moral rights, which I think is really useful for businesses, and it's something that you should have in your toolkit. Some things to keep in mind about copyright. So it doesn't last forever. The duration of copyright protection in Australia lasts for the life of the creator plus 70 years after their death in most cases. Of course, there are slightly different times for film, sound recording, broadcast. It's slightly different, and it depends on when the work was first published. In the next slide, I've got a summary that comes from the Copyright Council of how this works. The extended protection period ensures that creators and their estates, when you think about it, 70 years after the creator dies, can benefit from the work while encouraging further creativity in society. The duration of copyright protection is pretty much the same worldwide. Clearly, copyright, which is a creature of statute, there are different laws in different places, but as a general rule, because of the international treaties that deal with copyright and because of the importance of copyright and trademarks in particular to international trade, for the most part, the period of time is pretty consistent. Even though copyright grants creators exclusive rights, there are some exceptions. Under, for example, the fair dealing provisions, copyright material can be used without permission for specific purposes like research, criticism, news, reporting, and even parody. These exceptions are limited and they only apply under certain conditions. So it's always important to go to the source and to check whether the use that you have in mind qualifies or whether the breach that you are concerned about falls within the exceptions or otherwise. The last thing I want to talk about is that while copyright protection is automatic, there are things that you can do to better protect your work. In Australia, you don't need to use that copyright symbol, but it doesn't hurt to do so. By using things like that, you can make it clear that your work is protected. If you're interested in allowing others to use your work, one of the key ways of doing that is through licensing it and collecting royalties. So ultimately, the business model will impact, the business model that you want to adopt will impact how important copyright is to you and in your business. As I mentioned, this slide, just look at it very quickly, come back and look at it. You can download it with the videos, of course. This is a high-level overview of the general rules for materials that are made and subject to copyright. It particularly applies, or these particular dates are since the 1st of January 2019, when some significant changes were made to the Copyright Act in relation to timing. So it can be a little bit complicated working out what the time is, but as a general rule for most things, we're talking about 70 years after the death of the creator. While copyright law is based on similar principles globally, there are some significant differences in how copyright is protected across jurisdictions. So understanding the differences can help you or help your business if it operates internationally. So let's think about some of the differences that you might like to think about. So most countries, are signatories to some international copyright treaties, including the Berne Convention for the Protection of Literary and Artistic Works, and the TRIPS Agreement, which is the trade-related aspects of intellectual property rights. These agreements create a baseline for copyright protection across member countries, and this is one of the reasons why the time periods are so consistent. Under the Berne Convention, for example, copyright protection will be automatic without the need for formal registration, and the minimum term of protection is the life of the author plus 50 years. Of course, Australia, like many other countries, extend this to 70 years. Countries can vary how they implement the agreements, leading to differences in the enforcement and interpretation of those agreements. So ensuring that you understand what the rules are, even when you're in another treaty company, when you're doing business in another treaty company, is really important. In some countries, there are registration requirements. In, for example, the United States, for example, and there are a number of others as well. I've got a list of them somewhere in my notes and it's escaping me at the moment, but I know they include the US and Mexico. So copyright, so if registration is required, that ultimately means that it's difficult to pursue legal action for infringement in those jurisdictions before or unless that copyright is actually registered. Copyright protection is automatic under the Berne Convention, but registration can be required to enforce the rights in court. So that's what happens in the US. But it's not mandatory in Australia or the UK, for example. But it can provide additional legal advantages, in particular evidentiary benefits, being able to demonstrate that you were the original author of the work. I've mentioned the duration of copyright. Moral rights, including the right to be attributed as the author and the right to object to derogatory treatment of a work, they're more robust in some countries than others. So in France and Germany, for example, moral rights are strongly protected and you can't waive them. But in the United States, surprise, surprise, moral rights are much more limited and might apply only to specific types of work. So, for example, visual art under a Visual Artists' Rights Act. Also, in some countries where the exceptions are different, so there is a fair use or a fair dealing exception. And the fair use doctrine and the fair dealing exceptions are different. So in countries including the US and Israel, they use a fair use doctrine. It's a flexible, open-ended exception, allowing the use of copyrighted material for a range of purposes, including criticism, commentary, education, and research. It's very much built into this free speech understanding. In Australia, Canada, the UK, and some others, the approach we take is a fair dealing exception. So it's a more restrictive system that allows only for specific purposes, including research, review, news reporting, and to a certain extent parody. The last thing I want to talk about is technological protection measures, or TPMs. Some countries impose stronger restrictions on the circumvention of technological protection measures. So, in other words, the technology steps that companies make to stop people from copying their copyright material. So, in the European Union and in the US, there are strict laws that protect TPMs, often implemented under the Digital Millennium Copyright Act in the US, so the DMCA you might come across in your research, and directives in the EU that are similar. But countries like India, for example, TPM protections are less rigorous and enforcement is often inconsistent. So technological methods may not help you protect depending on what jurisdiction you're in. So let's bring us back now to thinking about how copyright, one of the key issues with copyright, particularly when we're looking at artistic or literary works or the kinds of works that are created by artificial intelligence, that if they were created by humans might be covered by copyright. So this case goes back a number of years now. In 2011, the photographer who you can see, the man on the slide holding a picture, his name is David Slater, and he was in Indonesia photographing wildlife, and a macaque monkey, who's given the name Naruto, basically took the camera from Mr. Slater and took a selfie. It became the image that you took. Look, it's quite beautiful, don't you think? It's basically referred to often in popular culture as the monkey selfie. So Slater basically sought to publish the work. I think it was published in National Geographic from memory, and Slater was taking royalties from this work. And then so an organisation called the People for Ethical Treatment of Animals, often referred to as PETA, filed a lawsuit on behalf of Naruto, the monkey, arguing that the monkey, not Slater, should own the copyright to the photos because the monkey was the actual creator. So the case, and it's got quite a long name, Naruto, a Crested Mark, by and through its next friend, People for the Ethical Treatment of Animals, Inc., and Archie Engelhardt, PhD, plaintiff, V for versus, because it's in the US, versus David John Slater, an individual, Blurb, Inc., a Delaware corporation, and Wildlife Personalities Limited, a United Kingdom private company, who were the defendants. So what was the legal question? The case raised critical question. Can a non-human entity, like an animal, hold copyright to a creative work? PETA argued that Naruto, being the creator of the work, should be entitled to own the copyright, with PETA acting as his or its, I can't remember, I think Naruto was a boy monkey, but gender is a construct, so let's say PETA acting as their legal representative. Mr. Slater countered that since Naruto was an animal, they couldn't hold copyright under US law. Ultimately, the US court ruled against PETA, stating that animals do not have standing to own copyright. The court found that under the US Copyright Act, only humans can hold copyrights, as there was no precedent or statutory authority that extended copyright protection to non-human creators. So this was the Ninth Circuit Court of Appeals. Ultimately, the case was dismissed in 2018, and it addressed a range of broader implications. So if animals can't be sued for copyright ownership or if they can't sue, I should say, for copyright ownership under current US laws, so then ultimately Naruto, as a mark monkey, couldn't be the copyright holder for the selfies. So this is really relevant by analogy to the question of whether an AI-created work can be subject to copyright protection. Much like Naruto, AI lacks legal personhood, raising questions about the ownership of the work created without a direct human input. Just as Naruto was the physical creator of monkey selfies, AI systems can autonomously generate creative works, music, images, text, and so on. The central question when we're thinking about this is whether a non-human creator can hold copyrights. Now, when we looked at moral rights, we see that moral rights can only be held by individuals. The law says that. Do we need for the law to be expanded to provide that moral rights could be held, for example, by the person who created the prompt? Legal personhood in copyright is another issue here. In this case, the courts ruled that copyright is restricted to humans because the law assumes that a creator must be a legal person. And I'm pretty sure that the law would see it the same way in Australia. Similarly, most legal systems currently require human authorship for a work to receive copyright protection. AI, like an animal, doesn't possess legal personhood, and that complicates the issue of ownership when content is generated autonomously by AI. In the monkey selfie case, the courts highlighted the importance of human input and control in the creative process. Similarly, with AI-created works, one might also ask who, if anyone, has contributed enough to the process to claim that ownership. Should the developers who programmed the AI have ownership? Should the person who provided the prompt have ownership? Is it the AI itself? These are really interesting questions, and they still need to be thought through. Under Australian copyright law, we need to have a human author. So AI-generated works might not be eligible for copyright protection under current legal frameworks. This presents a challenge because AI technology becomes more advanced and more capable of creating works independently. We can see that that is likely to happen. And if an AI creates a work, then we need to ask ourselves, should the copyright belong to the person who created or trained the AI, the user who input the data or the prompts, or the public domain? And many argue that AI creation should be public domain. Naruto and Slater suggest that without human authorship, the work might not qualify for copyright protection at all. So there are calls for legal reform. As AI systems generate more works, pressure is mounting for copyright laws to be reformed to address the issue of non-human creators. Just as the monkey selfie case sparked a debate amongst animal rights activists and copyright lawyers, AI-generated works are prompting discussions about whether the law needs to be updated, questions about whether it's fit for purpose, and do we need to change it to reflect the evolving nature of creativity. The next couple of slides, I really want to focus on some of the things that businesses need to consider for cross-border copyright protection and to think about their copyright legal strategies generally. It's worth asking the question, is it necessary to register this copyright? As I mentioned before, in some jurisdictions like the US, registration is a prerequisite for bringing an infringement action. Even in countries where registration itself isn't mandatory, so like Australia or the UK, there are opportunities to record your copyright that can help you provide evidentiary advantages. Businesses might think about registering key works in countries where they intend to operate or to enforce their rights, and consider registration in countries where there's a high risk of infringement or weak enforcement mechanisms. Secondly, particularly if your business goes across borders, businesses need to be aware of the differences between fair use and fair dealing and how these doctrines might apply in different countries. That requires familiarising yourself with how local laws interpret exceptions and limitations in copyright and developing strategies to manage how copyright works are used legally in various jurisdictions by implementing, for example, licensing arrangements or providing permissions. It's also a good idea to have a plan for what's going to happen when the time runs out. The duration of copyright protection varies across countries, so businesses need to think about what are the terms of copyright protection in their key markets and how can they fully exploit their works during that protection period. And pay attention to the countries with shorter copyright terms and strategize on how to extend protections where possible. So, for example, by creating new editions or new versions. Another issue is whether or not you can leverage international treaties. So if you're operating under international frameworks like the Berne Convention or TRIPS, businesses can benefit from automatic protection in a range of countries. But they need to be aware that the enforcement of the copyrights can vary significantly between those jurisdictions, particularly in developing markets where enforcements might be weaker. And working with local counsel or local lawyers in key markets will help ensure better protection and help businesses navigate the legal landscape. Really, this comes down to being able to recognise when it's a legal problem, and if it is a legal problem, when it needs expert local counsel in a particular jurisdiction. Clearly, there are other strategies companies need to think about, including monitoring global infringements and enforcing their rights across jurisdictions, and also thinking about moral rights considerations. So in the countries where there are strong moral rights, businesses need to be careful when they're using or modifying works to ensure compliance with the rights. And also, ultimately, thinking about strategies involving technological protection measures, TPMs, so encryption, digital rights management, and other tools that will help prevent unauthorized access to the copyright material. This slide, I start with the question, is copyright the answer? But we really need to think about, well, what is the question that we are asking here? And I've really got a set of questions on the slide. These are all things that I've already spoken about in this video, so I'm not planning to go through each of them. But they're really kind of a grab bag of questions that might be relevant to and might be interesting to you as you think about your final assignments in this course. And again, this slide also really takes us, it continues on this same thing and really just tries to provide a little bit of a summary of some of the material that is on Canvas. So it's just worth remembering that copyright is, it serves both as a tool for artists and it's also a weapon to suppress art in some ways, to stop people from using particular literary, dramatic or other works in a new or a different way. Algorithms and AI are impacting copyright enforcement globally. Europe's Article 17 of the DSM directive, the European Digital Rights Management Law, effectively, pushes responsibility onto the platforms. YouTube's Content ID system has caused a whole heap of fair use disputes, but they argue that it is really a way that they're trying to ensure that their responsibility as a platform to comply with the European laws are met. Generative AI is offering new opportunities, but there's a whole lot of questions around whether granting copyright to AI works could either enhance or hinder innovation. So there's a lot of material about this on Canvas, and I would strongly recommend that, particularly if this is relevant to your assignment, that you have a good look at it. And then in the next video, I'm going to talk a little bit more about patents. In the meantime, question, concerns, frustrations, suggestions, compliments, please send me an email.